Well, you emphasize the remote nature of the injury, the small number of adverse effects, the likelihood that patients will go to the emergency room, and so on. Is there a number at which your argument would change? The significant number of consequences, a higher likelihood of an emergency room visit, doctors who spend more time in the emergency room. At some point, does this analysis lead to the other result?
It's hard for me to imagine that it could, and there are a couple of different reasons for that. I take the point that you might pick out different links in the chain and suggest that there are ways to wildly depart from the facts here and suggest maybe as a statistical matter, one or two of those events could be probabilistically more likely to occur. But we have an objection here to the underlying theory as a legal matter because it rests on so many different things that would have to happen one on top of another and that turn on independent decisions made by third parties who are strangers to this litigation, who are not part of the suit. So we think that brings the case within those like Clapper or Summers, where this court has recognized that when the theory of injury really turns on so many different intervening events separated by independent decisions, it can mean that there is just an insurmountable hurdle to establishing standing.
Could you provide a more specific answer to the first question that Justice Thomas asked you? Is there anybody who could challenge in court the lawfulness of what the FDA did here?
In this particular case, I think the answer is no.
Well, that wasn't my question. Is there anybody who can do that? Let's start with the states that intervened below. Will you say in that litigation, fine, you can challenge it, and let's get to the merits of this issue, the lawfulness of what the FDA did?
No, we think the states lack standing. They're asserting indirect injuries that would, if it provided a basis for standing, mean that states could always sue the federal government. And the court cautioned against that result in United States versus Texas, footnote 3 of that decision.
Okay, how about a doctor who opposes abortion? So she's on duty in an emergency room when a woman comes in with complications from having taken Mifepristone, and the doctor's the only one there on duty who can attend to this woman's problem, and as a result, in order to save her life, the doctor has to abort a viable fetus. Now, would that doctor then have standing to seek injunctive relief, or would you say that's too speculative? This was like being struck by lightning, and there's no, it's not sufficiently likely that this is going to happen to this doctor again.
We would agree that that would represent past harm, so we're not disputing that that kind of conscience violation, providing care in violation of one's conscience, would be cognizable. But yes, we think that that situation has never come to pass. Respondents haven't identified any incident in more than 20 years that Mifepristone has been available on the market that resembles that kind of hypothetical situation. And so, yes, our view would be it's unduly speculative. And you have to think about all of the events that would have to transpire to get to that moment in time.
Sure, no, I understand the argument. Now, how about a woman who suffers adverse consequences from having taken Mifepristone? Would she be able to sue for damages? Or you would say that's barred by sovereign immunity?
I expect that we would have sovereign immunity arguments in that kind of case. I recognize that with respect to traceability, that's a harder argument for us.
Okay. Is there anybody who can sue and get a judicial ruling on whether what FDA did was lawful? And maybe what they did was perfectly lawful. But shouldn't somebody be able to challenge that in court? Who, in your view? Who would have standing to bring that suit?
I think that with respect to these regulatory changes, it's hard to identify anyone who would have standing to sue, but the court has said time and again that the fact that no one would have standing doesn't provide a basis to depart from Article 3 principles. It said that in Raines, in Richardson, in Valley Ford, and in Clapper, and so I think it's clear that even if there is no alternative person here who could sue, that doesn't mean that the court should dispense with the indispensable requirements of Article 3.
Okay, I understand that, and Article 3 is important. So your argument is that it doesn't matter if FDA flagrantly violated the law, didn't do what it should have done, endangered the health of women. It's just too bad nobody can sue in court.
Certainly we think that
there's no remedy. The American people have no remedy for that.
Well, I think that it would be wrong to suggest that if FDA had made a mistake and a drug were actually producing safety consequences, that there would be nothing to be done. I don't think that these respondents could invoke Article 3 jurisdiction to have the court step in, but FDA takes very seriously its responsibility to ensure the safety of drugs. It conducts ongoing surveillance and can make adjustments to the regulatory regime if safety situations emerge. The drug sponsors themselves remain responsible at all times. We have a tort system in this country, and that can help ensure that if there are safety problems that come to pass, the sponsors will take action in reaction to that. So if the premise here is that unsafe drugs could somehow remain on the market, I think that that's incorrect.
I mean, so your argument here is, and as I said, I have great respect for Article 3. We all do. We have to comply with it. But your argument here is that even if the FDA acted unlawfully, nobody can challenge that in court. And that's basically the argument you made last week, right? In the Murphy case, we shouldn't get to the question whether the White House and others violated the right to freedom of speech. We should just say, well, these plaintiffs can't bring suit, right?
We are looking at the specific respondents in this case and their theories of standing. We don't think they come within 100 miles of the kind of circumstances this court has previously identified of non-speculative harm that can create the kind of cognizable injury for forward-looking relief.